Good day, Advocate Mahomed.
Good day, Chief Justice.
How are you?
I'm well, thank you.
Good. Whew, you have a string of academic qualifications.
That is correct, CJ.
You have 3 degrees, a BA, LLB, and LLM from the University of Natal and Pretoria, Universities of Natal and Pretoria. Your LLM was in corporate law.
That's correct.
And then you have this string of diplomas and certificates on a wide range of subjects.
Yes, CJ.
You lectured, which makes sense, seeing that you love education so much.
I do, yes.
But that was for a brief stint.
That's correct.
How long?
CJ, I was employed as a part-time lecturer at various institutions. So I was trying to fund my studies, and this was one way of doing it. So I've worked intermittently at least 2 or 3 technical colleges in those days. So one of them was the Mangosuthu Technikon in Mlazi. And I must have been employed for about 3 or 4 years on a part-time basis. These were evening studies, so I was teaching adult students.
All right. And then you decided that you wanted to practice?
I was working through to get to practice. When I was teaching, I was also a student at the time.
All right. So you did articles between 1992 and 1994, then started practicing.
That's correct, yes.
Made your way from professional assistant to partner by 1997.
Yeah, partners sounds rather impressive, but I'm afraid it didn't work out too well for us.
So you were an attorney for about 4 years?
That's correct, yes.
And then you decided to join prosecution?
Yes, I was interested in the work of public protector.
Oh, no, sorry. The public protector. You joined the public protector as a senior investigator.
That's correct, CJ.
How long were you there?
I was at the public protector for about 2 years, and then joined the office of the Scorpions at the time.
Yes. As a senior state advocate.
That is correct, yes.
And then you went on to Legal Aid SA as a senior attorney.
Yes, I joined the Legal Aid Board after that.
Yeah. What did you do thereafter? Your questionnaire stops there.
CJ, I joined the bar after I completed my time at the Legal Aid Board. I was interested in litigation itself, doing the work myself, and I've been at the bar since 2007.
That's quite a checkered legal career.
Yes, it is.
You have acted as a judge?
I have, CJ.
Where and for how long?
CJ, I've worked in both the Pretoria and Johannesburg courts, and I've done a total of 60 weeks.
And what kind of work did you do during your acting stints?
CJ, I have worked in almost all courts across these 60 weeks, barring the tax court.
All right. So did you, I assume by everything you mean criminal and civil across the spectrum?
I've not sat in a criminal trial.
You have not?
No. But I have some criminal experience as a young attorney. A lot of my work was from the Legal Aid Board. So I have done some of that, and being part of the Scorpions, obviously I had to develop prosecution mind as well.
Yes. You attended the aspirant judges training program?
Yes.
Twice?
Yes.
Did you find it useful?
Oh, yes. It's very important to be able to extract as much information on the real life of court. And I call it getting court-wise. There's a significant difference between an academic practitioner on the other side, but being on the side of the bench and getting a sense of the atmosphere and what to expect is very useful exercise.
Yeah. What kind of work do you do in your practice?
As an attorney?
No, as an advocate.
Oh, as counsel, I primarily was briefed with the road accident fund work, and I did some family law, and in between a few labor matters that crossed my desk.
Your last acting stint was this year in May.
Actually, the last term, CJ. I served the last term.
The whole term?
That's correct, yes.
And you've written judgments?
I've written judgments. I think I have a total of 85 judgments.
85?
That's correct.
Okay. Have any of those been reported?
I've reported one, CJ.
Okay. When you completed your application form, you listed a reserved judgment, just one.
Yes.
And you promised that it would be delivered some time back.
Yes,
Was it actually delivered?
Yes, it has been delivered.
So you don't owe anything?
I owe one from the last term.
It's still from recent times?
Yes. Yes.
Okay. All right. I'm going to ask Judge President Mlambo to put questions to you if he has any.
Thank you very much, Chief Justice. Good morning, Advocate Mahomed.
Good morning, JP.
I just want to deal with your exposure to the Gauteng Division work. According to the spreadsheet that should be in front of you there, you started acting in 2020, just before COVID.
That's correct, yes. I did some pro bono service then.
Yeah. And I see you the only candidate of all of them that's done 9 full weeks in the opposed motion court.
Yes.
Throughout your acting stint.
That's correct.
Yeah. Is it an easy court to work in?
It's a highly pressurized court to work in, JP. Most of my judgments arise in the opposed court. And obviously, we have to meet a deadline, and
Yes.
I've managed to do so in most of my matters.
Yes. And you've done 1 special motion week as well as 1 urgent court week.
JP, I just looked through your spreadsheet, and I realized that I robbed myself of 1 week. Which, I'd forgotten about the week in the recess. So I agree with 60 weeks.
For the urgent court?
No. This is for the total weeks.
Okay.
As far as the urgent is concerned, you are correct.
Okay.
And as far as the special motions are concerned, I think I put 1 matter into a different category, but I have actually done 2 special motions.
Okay, thank you very much. That's fair. So, and let me just look at this. There's been 3 occasions, 4 actually, no 5, where you've actually come to act for a full term.
That's correct, yes.
5 full terms. And having done that, because that's the usual load that the permanent judge carries in Gauteng, you feel you are now ready to become permanent?
Yes, JP, I feel confident. I think I have become somewhat court-wise.
Yeah. Right, let's deal with your judgments. I've done a scan of them all. There's about 3, I think, that were just over, that were 4 months. And then there's 1 that was, I think, 5 months. And then there was 1 that was long, reserved for about 9 months.
That's correct, yes.
And I don't want to tell the commission what happened there, but can you tell the commission what happened with that matter?
So in regard to the matter that took me 9 months, the matter was set down as a trial of long duration for 15 days. It finished on 28 days.
That's what we call a special trial.
This is right, yes.
Thank you.
And I had to traverse a very, very long court record of 3,700 pages, and the evidence from 18 witnesses. The closing arguments were heard on a few days just before I commenced a full term. I couldn't find the time to work this judgment because the full term I managed to pick up about 14 reserve judgments. I prioritized those, and if you look at my list of judgments, they've been dated, so you have a sense of how regular the judgments were delivered soon after the term. And as soon as I was done with that, I commenced with the trial of long duration. In the time, JP, I would like to tell you that I had kept contact with the attorneys and advised them as to my progress in their matter. And the extension of time I had come to you to discuss this matter with you, and you were kind enough to offer me extra service if necessary. I didn't need that simply because I just had to get through the very long trial record. And it was important for me to read this trial record because the parties were very passionate about this. And I thought about the next step this judgment may take, which is probably in a senior court. And I thought for that reason, I needed to actually do a little bit of cross-referencing as well. So this took me a while, and I do my own typing. So
I think the issue is you realize that this was a complex special civil trial, and you required more time to give the judgment, but you kept the parties informed of what was happening.
Oh, yes, yes.
Because I didn't receive a single letter of complaint.
Right.
And you actually came to me as head of court to say, this is going to be beyond the allowable periods.
Yes.
These are the reasons. Please allow me the space. So that's what happened. But that's the only one. Am I correct?
Sorry?
That's the only one that took that long.
Oh, yes, yes. I
Yeah.
have delivered most of my judgments in the required 3 months.
Yeah. Okay. Now, your judgments span quite a wide spectrum, so I'm not going to go through that. But I'm sure you would have heard me say to the other candidates, I have a scoring matrix. I'll score you after this interview. I'll score you on your exposure to the complex work, and I'll score you to the time it took you to hand down your judgments, right? Do you have any comments about that? Well, maybe the direct question is, in terms of your exposure to complex work in the division, out of 7, how much would you score yourself?
JP, I've had a number of long duration trials and 2 special motions. I've dealt with them independently without
Yes.
any real support required. I would place myself, given the 9 months that I'd taken on the one matter, fairly without necessarily overstating my case, at about 6 of 7 or 6.5 perhaps.
Okay, no problem. Thank you, Chief Justice. I've got no further questions.
Thanks, JP. Premier?
Thanks, Chief Justice. I don't have questions for this candidate. Thank you so much.
Thank you very much.
Do you have questions for the candidates, commissioners? Commissioner Gauteng?
Hi, hello.
Hello,
Advocate.
Commissioner.
How are you today?
Very well, thank you.
Good. With reference to news reports that civil claims in one of Gauteng's courts could only be heard in 2029, it was recently reported that legal professionals are at their wits' end over the longest backlog in history. That's in quotes. What, in your view, is a judge's role in ensuring the expedience of the administration of justice?
Commissioner, I think I am aware of the very long trial role and the very heavy court role itself. I am committed to having my courts attended to as soon as I can, my work as soon as I can, and certainly in terms of the delivery of judgments. I think that a judge can also develop an ability to identify delays that arise within the courtroom itself. So that is an important skill that a judge has to, and this is where I think when I speak about getting court wires, this is one of the ways in which a judge can be firm as to the pace at which matters actually proceed. I often also adopt the approach that if I had requested something, I would provide a timeline. So by then, parties are required to actually respond. And I make it even easier by ensuring that I provide what would be virtual platforms sometimes just to expedite matters.
Thank you.
Commissioner Mangen?
Thank you, Chief Justice. Good afternoon, Advocate. I'm here on your other
Thank
right.
you. Sorry, thank you.
On your other right, which is your left.
Right,
Yes. Advocate Mohammed, I want to commend you on the judgment of Eva versus Eva. You
Yes.
remember that judgment?
Yes.
That judgment that you were dealing with the Rule 43 application. And one of the issues that came for adjudication by you was the respondent's duty to help the applicant in finding accommodation, because at that time the applicant had left the matrimonial home and went to stay with her parents, and the respondent refused to make contribution towards that shelter. And in the course of your judgment, you made reference to the duty of support and its connection to the right, to the constitutional right to housing and dignity. And ultimately, you arrived at a conclusion that the respondent, who was the husband, has an obligation to pay, to make a contribution towards that housing need for the applicant. Now, I thought that was brave of you, but also that was beautiful, because you were able to bring in the constitutional values required in adjudication of disputes. But secondly, it is a matter that it's affecting mostly women who are in relationships which, when divorce is looming, are preceded by what is the word? English is escaping me. Turmoil and abuse. And as an escape, they move out of the matrimonial home, take refuge either with friends and or with family. And in that instance, if the matter comes before a judge who is insensitive, or a magistrate in the regional court who is insensitive, more often than not, those kind of vulnerable people do not get the assistance that they get. What's your view on it?
Yes, I'm pleased to hear that I have a support on that aspect, Commissioner, and also that the vulnerability is on both sides of the gender base. The reality is that it is a skewed situation, and obviously based on the economics and men in the society are better supported economically. In this instance, though, the respondent left the home from a domestic dispute where he had been unfaithful to her. And he continued to reside in the marital home. And he continued to maintain the same lifestyle, living in the marital home. And the evidence before me was that whenever he needed to pursue social, some of his hobbies, he would take loans from his businesses and hold up loan accounts. And my view was, well, he has access to capital to support himself. He must find some access or some capital to contribute to what is a basic need of accommodation. And she demonstrated that she couldn't afford it because she continued to live with her mother for many years.
Thank you. Thank you, Chief Justice.
Commissioner Nongonyan.
Thank you, Chief Justice. Good afternoon.
Good afternoon, Commissioner.
Madam. Like Commissioner Mangena before me, I'm impressed, but I'm impressed. Respect of another case. I think it's Kastler, Say, and O'Neill, the Israel applicant that he made an application to have his children travel with him to Israel.
Yes.
And I'm impressed about how you balance the interest between these two litigants and to ensure that they're coming. But my question is, how old were these children? And bear in mind that Israel is notorious. It's not a safe place for one to go to. It is in that context that I'm asking. Are you able to share with us how old are these children?
Yes, Commissioner, I think Israel has become part of the news after this judgment was delivered. So at the time, the children were wanting to join their father to visit their family out in Israel. They were, to answer your question, between 10 and 12 years old. And the application was simply for a removal for a limited period, and they would return once the school holidays were over. But the volatility in the area had arisen after this judgment was delivered. This judgment, I think, was delivered sometime in December of 2022.
Thank you, CJ.
Deputy President Zondi.
Thank you, Chief Justice. Good afternoon, Advocate Mahomed.
Good afternoon. Sorry, Commissioner, I don't know where you're sitting.
Oh, I'm here.
Thank you. Sorry, President.
Okay. I see that in 2006, you attended a fellowship or leadership program in the U.S. investigating ways to develop class action litigation in South Africa. Now, that experience that you acquired in the U.S., have you been able to put it to use it, having regard to the socio-economic situation in South Africa, more especially for those who, for those employees who worked in the mines and they contracted some respiratory-related diseases? Were you able to put that experience into use?
Thank you, Commissioner. I was part of the silicosis litigation against mines on behalf of mine workers. I can't say that I was part of the main litigation team, but I was included on the team. I was responsible for the discovery of documents. We had to go through not less than 1 million documents, and literally so, I'm not exaggerating. That was handed over by the defendants in the matter. And on that basis, I was able to understand the impact and the logistics that are involved in class action litigation. I have not been involved in any of the others that have arisen since then.
Thank you. Thank you, CJ.
Just follow this up. Advocate Mohammed, who are you acting for? Because that case, if it was the Ngala case, that's the case that caused black advocates to protest in court because blacks were not included in the plaintiffs or the defendants' team.
Sorry, Counsel, I apologize, Commissioner. This was the silicosis litigation that was against Anglo and its partners.
Yes, but that's the one, it's Ngala, the actual designation is Ngala.
Yes, yes.
Because I seem to remember that case that we went to protest because black people were excluded. So who are you acting for?
For the plaintiff in the matter, the mine workers. And Commissioner, this was the very first matter that appeared before the court in terms of certification. So I'm not sure if that is the...
Yes, Commissioner Pillay has just shown me the list of counsel. Your name is not here.
Yes, as I said, I was part of the discovery team. I was responsible for discovery. If perhaps Advocate Moultrie was part of the team, led by, I think, counsel based in Cape Town. If I can't remember, it was...
This is the judgment of the full court with Mojapelo, DJP, Valley J, and Windell J. That's the case I remember that AFT organized the protest. And we've got the list here, and you are not here.
Well, I did, Commissioner, set out that I was not part of the main litigation team, but I was part of their team in terms of having to go through the various documents that were discovered in that matter.
All right, thank you.
Yeah, thank you, Chief Justice. Good afternoon, Ms. Mohammed.
Good afternoon, Commissioner.
Ms. Mohammed, based on what you were saying, you would have been one of the only black people involved in the matter. Did you note that there was a problem with the composition of the team?
Oh yes, definitely was very skewed, and but I can't say that I was actually the only black person. Skikakana SC was also part of the, well, he's SC now, but at the time he was part of the, we shared the covering of those documents.
And did you raise your concerns with the leadership of the team?
I did not raise my concerns as I ought to have. I was pretty new at the bar. I just joined the bar, and one has to understand the culture. It takes a while to understand the culture, and but at some point I had indicated, I think there was limited room for a teleconference, and I offered to remove myself from that because I communicated that not much work was really being assigned to me beyond reading documents. And I must say that is as far as I had gone, and I was then replaced at some point. The management team called me to say that they needed to free up legal fees, funds, to employ other counsel.
And you offered to withdraw because you felt that you were not being effectively used?
I offered to allow another counsel or any other counsel to join this teleconference because there wasn't sufficient space for everybody. And because I really wasn't being given anything specific to or to contribute effectively to it. Yes.
And in your many years at the bar, Ms. Mohammed, have you utilized black juniors in your matters?
Commissioner, I have not, for the reason that I myself considered myself a recipient of those sorts of opportunities. I did get at them, and as I said, I pointed out that a lot of my work was road accident fund based, and anything else was really from a very small law firm. What I can tell you is that my transformation efforts are honest. I haven't recorded them. I never planned that I would necessarily have to record what I do and who I do it for. And I'm certainly very committed to creating a competitive environment. And I'm fully appreciative of the position of women at the bar, particularly Black women. So as far as including people in my teams, I am afraid I myself didn't get the sort of work that would afford any additional counsel.
So if I understand your answer, the type of briefs, the type of matters that you were receiving at the bar was not the type that would allow you to bring in juniors, whether they be Black or white juniors.
Oh, yes, yes. And they were not reflective of the sort of skills that I actually brought to the bar. I joined the bar in my 40s. I developed a lot of skills over the years and joined on the basis that I know something and I could contribute, but I haven't had those opportunities.
Sorry, Chief, just two more questions. And you joined the bar having played a leadership role in the strategic litigation unit of the Legal Aid Board.
Oh, yes, yes, yes. I was invited to start up the impact litigation unit for the Legal Aid Board. It was very new to the Legal Aid Board in terms of the concept itself. And I managed to effectively set up this unit. I briefed certain councils, Johannesburg, Cape Town, across the country. So yes, I did develop that kind of skill.
And coming to the bar with this level of skill, why do you think that you were not able to get the kind of work that you ought to have gotten at the bar?
Yes, it is a challenge, Commissioner, and that challenge continues. And I think we need to understand, I wish I had known the environment before I even joined it. I would never have joined it because the reason I apply here is about how effective I can be given my varied skills. And I've never had that opportunity as counsel. Whether I was sidelined for various reasons, I have no idea. But I can tell you that, having joined the group, obviously I had to submit my background, which I had. I certainly was a team player. I have no enemies. I've remained in the same group for 15 years, and I take note from one of your training sessions that I ought perhaps to have moved on, but I didn't. And as to the reasons, well, the reasons are often about dominance of certain genders, certain race groups. I know that I can say that the white female does better than the Black female. They are better looked after. Perhaps not in the last 2 years, perhaps the playing fields have leveled, but I'm past the 2 years. I've been there for 15 years. So as to what is really happening on the ground, I might be a little divorced now. And I'd like you to also appreciate that at 40, you expect people to appear and address you with sincerity and at a level of professionalism, which I found to be different. So as an older person, I'm not sure about other people's experiences, but when you're older, you tend to say, all right, I can move on and do my own thing. But it is a difficult terrain. It's an extremely difficult terrain. And and I want to add, the JP has told me to keep my answers rather short, but I want to add that in the years that I've served as an acting judge, I make a concerted effort to ensure that there is fair cross-pollination of skills. So if you arrived, and this is from the very first court, the unopposed court that I run, and I've done it through all of my unopposed courts, I inform counsel who are senior and often sit in front that I'm going to be taking them through the very basics of their applications so that those who sit behind them may learn something, particularly in that whether they will get a similar brief is a big question. And when juniors do come in to introduce themselves to me, I alert them to the fact that my court is going to be a teaching court. Unfortunately, it has to be that. That is the need on the ground at the moment. The other concerted effort I make in terms of transformation is that I approach my judgment writing at a level that demystifies the law, actually, I hope, where a reader gets right into the topic, understands the area of law, because I believe also that we have just so much of reading to get through. And particularly in this division, we are so busy. So I'm hoping that through my judgment writing, as others may view it as basic, I'm willing to take that risk for now. I'm very committed that the people who appear before me, if I'm ever appointed as a full-time judge, are going to appear before me on effective arguments. And the way to do that, in my view, from the bench is offer these sorts of opportunities to grow and to build a level of confidence.
Thank you, Advocate Mahomed. Thank you, CJ.
Sorry, I really do want to get clarity on this thing about the silicosis case.
Yes.
Because I'm not sure if I understand your answer. Why did you end up not being in the final list of the advocates? Because that list was all white. If you say you were involved at the beginning of the case.
Commissioner, I'm in 2007, when I joined the bar, toward the end of that year, I was contacted by counsel to, let me just take a step back. Before I joined the bar, I was the manager of the impact litigation unit of the Legal Aid Board. I had read through the proposals put for funding in this matter, and I got approval to fund the matter at R1 million, which in Legal Aid Board terms was a lot of money. And I think I was remembered when I joined the bar, and on that basis was invited to cover what would be the discovery, the documents that were discovered by the defendants in the matter. I had completed that together with counsel advocate Skikakana. And after that, I think the management team decided they needed to probably bring in more people, but that's as far as I had gotten.
But what happened? Were you removed? Did you resign from the brief? I'm trying to understand whether it's part and parcel, because we, at the time, I think this was a 2013 case, 2014 case, when it was the first time black advocates protested inside of court because of racism.
Yes.
And I had no idea then, even now, that you were actually in the case. So I'm trying to understand whether your removal from the case was part of a racist practice, or how it happened that a black woman was once in and then disappeared.
Commissioner, I'm not able to answer that question effectively or with any kind of commitment, other than to say that I was contacted to say, we need the funding that we have for you to employ another.
No. Chief Justice, no. May I just follow up on this? Advocate Mahomed, you were aware that you and Advocate Skakan were the only two black people working on this matter. And probably at that time, you were aware, as a member of the bar, of the discomfort that's in the corridors about lack of briefs. And when you were taken off the brief, did you accept the reason? And if not, what other steps did you take to make sure that the bad treatment that you were receiving does not continue?
Commissioner, to be honest, I had been running low on funds by that time. I was focusing on building my practice as best I could. And it's been a struggle throughout. It's just been a struggle. As to my efforts, well, I tried to support whoever my colleagues were, who may have raised issues with me. But it's been an uphill battle, and it's a huge mountain to climb, simply because there isn't also, and I'm talking way back in 2007, the terrain has improved, definitely, in the last 5 or 6 or 10 years, perhaps. But when I started as well, there were no real support mechanisms for Black Council. I think that the system was just sort of developing with the AFT, but in terms of effective support, that has grown. That definitely has grown. But at the time, I think I was also rather intimidated by all of this at 40, and I was really trying to focus on how best I can build a practice.
Did you get a sense that you were being removed and taken off the brief because you are a black woman?
Well, within the context of where I found myself, and on reflection, it may well have been one of the factors.
Thank you, Chief Justice.
Commissioner Kane.
Thank you, Chief Justice. Good morning, Ms. Mahomed.
Good morning, Ms. Kane.
On the last occasion that you were interviewed, I think in late 2023, I did ask you about the 2 cases that you list as being your most significant. And it's traversed in paragraph 6.3 of your application. On that occasion in 2023, you made reference to the 2 cases that you repeat in the current application. The one concerns the failure to notify a person who owned a motor vehicle that he was in arrears and that his car would be possessed. And the other concerned the failure of a medical practitioner to fill in a form properly, and it was held that the treating doctor had been in substantial compliance of filling in the form. On the last occasion, I said to you that this would evidence a lack of experience as an advocate. And I just ask you now why it would be that you come to this body on the same information with no new evidence that you have a practice that you've developed further in any way.
Well, the time period between the submission and my last interview is a year. And I have no matters that have gone into court or had any kind of, has not necessarily developed since then. And whilst I do have some matters on my desk, they're still in infancy. And the truth of the matter as well is that I'm focusing on this appointment. So I've served a lot of my weeks as well in that time away from my chamber. I've not been taking on, because it does impact, Commissioner, on one's work as well. I obviously have to be vigilant about being available for my client. And so to take on a new client would be a risk. So this has been the reason why I haven't been able to come up with anything current or since then. And in regard to what may appear to be the sale of a car, as I remember you had raised the last time, it was really about the consumer rights protection within the National Credit Act that I had identified. But perhaps I should give you what I hadn't conveyed the last time. And again, it was from simply not understanding whether these are emotional issues that one raises. But be that as it may, this matter is important to me and will continue to be important to me, because when I received it, it was a hand-over brief in an interlocutory matter. At the time, I had reached a point in my career where I thought I really had not much to offer, because the briefs were mediocre and really peripheral in practice. I had some advice work that I would do, but nothing that would take me to effective argument in the motion court. When this arrived and I identified what would be a constitutional debate, which I can assure you, the attorney who handed this matter, or my colleague who handed the matter to me would never have handed it to me if she had herself identified that this was the potential for this matter. And that is the context in which this matter will always be meaningful to me. And I stand by this, because that has been the challenge. And in many instances at the bar, this challenge continues. And the only way I think that we can overcome this is if we identify it for what it is and see how best we can address these issues. But this was my experience then. So this matter will be useful for me. I was able to identify a constitutional debate. The presiding judge was a respected judge who asked for further heads of argument. And unfortunately, I couldn't continue for two reasons. One, the attorney would, having identified the potential for this matter, had not come back to me. And subsequently, I was advised that my opponents had withdrawn the matter, which was the bank.
Thank you, Chief Justice.
Thank you, Ms. Kane. You have had significant acting experience since we interviewed you in October last year, haven't you? I
Yes.
remember that the complaint from the professional bodies as a whole was that you did not have sufficient acting experience and you could benefit from more stints which you got.
That's correct, yes.
And I see now that all those professional bodies, including the GCB, actually think you'd have value to add. Your appointment would have value to add to the institution, the judiciary.
Yes.
All right. Okay. Are there any questions from the virtual platform?
No, thank you, Chief Justice.
None from me, Chief Justice.
Commissioner Mtweni? All right, I'll take your silence to mean that she has nothing to ask. Just one tiny detail, tiny but important detail. I raised it with you in your previous interview. The fact that you are an accredited mediator with AFSA, and you spoke passionately about that and the value it would add in the running of our courts. So I won't ask you anymore. I just want to place it on record that you also have that skill.
Oh, yes, yes, and I am still very passionate about it. And in fact, just to respond to the question as to what the courts can do to speed up matters, this is also a very important tool to dispute resolution, and we have to, as a society and certainly within the legal fraternity, take this a lot more seriously. In fact, I'm going to, next week or so, be preparing a program for users of mediation as part of the membership I hold with the committee.
Right. JP?
Thank you very much, CJ. I'm sorry to ask this follow-up question, but Advocate Mahomed, I would like you to allay the concerns that both Advocate Ngugaitobi and Advocate Pillay have raised about your involvement in that silicosis matter, because it's not clear. I mean, were you only brought into that matter just to deal with documents or what? Because they say your name doesn't appear.
That's correct, yes. I was given a task to deal with all of the documents that were discovered by the mining companies.
And you say you were with Advocate who? Skakane.
Yes, Sikakane was doing the reading with me.
So you would have been aware of the protest?
That happened subsequent to my removal from the...
Or subsequent to your removal?
That's correct, yes.
Okay. But who was the leader of the legal team you were part of? Because the council at the top of the table, they do have the list. Unfortunately, they're too far from me. I'll take the list and show it to you. But, it would be good to know who was leading that team.
Sorry, JB, the name escapes me, but I know that senior counsel and the lead counsel was based in Cape Town, and I think he's since passed, I'm not sure. But there were a number of other counsels. I think we were about 7 or 8 on the team. And I do remember that Moultrie SC was also part of this team.
Moultrie? That's
correct, yes, yeah. And as I said, JP, it's not about identifying a person. I certainly didn't have bad experiences as a part of the team, but my brief was terminated at a point.
Thank you. Thank you very much, CJ.
Thank you, JP. Thank you for making yourself available again, Ms. Mohammed.
Thank you, Chief Justice.
Is there anything you want to raise with us?
Except to congratulate you on your appointment as Chief Justice of the Republic of South Africa. And I'm looking for a lot of leadership, and I'm sure I will find it.
Thank you. Thank you for that.
Thank you to the commissioners for this opportunity. And yeah, thanks.
Okay, you're excused.